고용주가 없이 진행할 수 있는 NIW와 EB1A, 빠른 수속 기간이 있다는 장점이 있는데요. NIW에 대해서 알아보는 시간을 가져보도록 하겠습니다. 엔지니어부터 의사, 교수, 많은 고학력자분들이 고용주 없이 빠르게 진행할 수 있는 영주권 루트로 NIW를 많이 고려들 하시는데요. 오늘은 미국 지사에 계시는 김성은 변호사님과 함께 NIW에 대해서 알아보는 시간을 가져보도록 하겠습니다. 오늘은 김성은 변호사님과 영어로 이야기를 나눌 예정이라 여러분들을 위해 아래 자막을 같이 띄워드리겠습니다.
The NIW may be exceptional ability, but the EB1A is extraordinary ability. Why? It doubles their chances of getting approved for their green card.
Hi, Janet.
Hello.
Hi. First of all, what is NIW?
NIW stands for National Interest Waiver. Now, the waiver comes in because if your work is considered as supporting the national interest of the U.S., they are waiving the requirement of an employer to sponsor your green card petition.
So what comprises of national interest?
Well, you can prove that your work supports the national interests of the U.S. in several different ways. If you can connect your work to certain government initiatives that the U.S. government is trying to advance or push through, or let's say, for example, during the pandemic, your work was tied to some kind of like a critical issue that the U.S. is facing. So during the pandemic, the COVID-19 pandemic, if you worked in that area and you could show you were a part of maybe the team that developed the vaccine, of course that would be within the national interest. Another thing is that you can show that if you don't work at a job, or your occupation does not tie in to such government work, you can show national interest by showing that your work has broader impact than just your immediate clients or just your immediate employer. So a lot of people think that nurses qualify for the national interest waiver. Why? Because they're helping patients, correct? Why wouldn't that help the national interest, right? But I regret to say nurses do not qualify for the national interest just by being a nurse. Why? Because you're only helping the patients at your hospital. There's no broader impact for what you do. If you're a nurse, let's say, a certified nurse practitioner, or, even a professor and you've been involved in certain areas of research, medical research and things, then we could show, there's a broader impact of your work. But if you're merely just a nurse helping patients, then you wouldn't qualify for the national interest. So you need to think about it broadly in the sense of how is my work going to help everyone
in the United States, yeah. So what evidence could you use to prove that national interest?
Well, a lot of times, a lot of our clients who come to us, there's two types. There's people who are engineers, doctors, researchers. They have ample evidence to show that their work promotes national interest because they've written publications, they have patents, they presented their articles or their work in front of many people at conferences. Also, they teach other people about their work. So those kind of people are those are the evidence that they would use to show that their work promotes national interest. But what about people who don't have that kind of evidence? Those people that we have worked with, we have to be a little creative with what they have. And again, this is done by case by case basis, based upon what kind of work you do, what kind of information that you're able to provide. For example, an engineer, who worked on multiple projects, and he was the engineer is just he was the key in these projects being completed. But how do you show that, right? How do you show that? Well, a lot of times we do take project documents, right, that he has drafted. We explain those documents, and how those documents that he has worked on affected the project. Now, the project would be affected in a positive way, such as cutting down time, costs, things like that. So we do try to be a little bit more creative in those situations, but like I said, it's case by case.
Right.
Yeah, and we have to discuss what kind of evidence that the person actually has and can submit to immigration.
Many people often say that another option or route would be EB1A for those NIW applicants. Are they the same? How are they different? Because I know that they both don't require the sponsor, correct?
No. EB1A also does not require an employer to petition for you for your green card. A lot of people think, if I qualify for the NIW, would I qualify for the EB1A? Or if I qualify for the EB1A, I would qualify for NIW. You have to understand there are two different categories, right? Two different categories with very different requirements. A lot of people think just because they say that NIW is much simpler, the requirements are less strict or less stringent than the EB1A. So they say, oh, well, if I don't qualify for the EB1A, then I'll just apply for the NIW. That's not always necessarily the case. For example, like we discussed, NIW requires that your work supports the national interests of the U.S. If your work does not, then you would not qualify for the NIW. The EB1A is a higher standard, though. The EB1A does require that, I always explain to my clients this way. The NIW may be exceptional ability, but the EB1A is extraordinary ability, right? So which means it's a higher standard. The EB1A, if you look on any immigration website, or if you seen the YouTube videos of other immigration law firms or immigration offices, they will tell you there are 5 requirements under the EB1A category, and if you satisfy 3, then you will
automatically.
That's not necessarily the case. USCIS is looking at the totality of your case. Yes, you have to meet those requirements. That is the minimum. You have to meet those requirements. But beyond that, they're looking at, when you meet those requirements, does that support your ability? Does that support that you are within the top percentage, that small percentage at the top of your industry? I'm going to say all the years that I have been practicing immigration law, I have done a total of 4 EB1A cases. That's how strict the standards are. And even with those cases, we have had multiple requests for evidence from immigration asking for additional evidence, because you need to really show that you are at the top of your field, okay? And like I said, though the evidence to support an NIW and EB1, it's going to be similar. Publications, patents, awards, recommendation letters, all of that is all going to be similar, but the caliber of such awards, or where the caliber of the journals that your publications were published in, or what your referrals are saying in their recommendation letters, that's going to be very different. So just because you qualify for one doesn't necessarily mean you're going to qualify for the other.
Good to know. Is it common to see anybody that qualifies for both categories?
Oh, of course. We have many clients who qualify for both. And I'm going to say, like, when we do give them the option, a lot of them decide to apply for both categories if they do qualify for both. Why? It doubles their chances of getting approved for their green card. For example, the EB1A cases right now for Koreans, for national Korean nationals, there is no wait time to submit your adjustment of status application or for your immigrant visa. So the EB1A process is going to be a lot faster, right? You're going to be able to get your decision from USCIS faster. You're going to be able to apply for your immigrant visa or for your adjustment of status much quicker, okay? EB2 NIW, when I first started, there was no wait time as well. EB1A was just like EB1A. But right now, the number of NIW applicants have tremendously increased. So right now, even if you are approved by USCIS, your I-140 is approved, you're still looking at about a year and a half to file for your adjustment of status or for your immigrant visa. So that's why a lot of people apply for both. I get my decision faster with the EB1A, but let's say I get denied, I can still rely upon my NIW application to get my green card.
So there's no disadvantage?
Oh, none at all.
Oh,
None
okay.
at all.
So if you are qualified for both categories, you can go ahead and just apply for
You can
both.
apply for both. Yes.
So in case you have a client who may be qualified for both but would like to just go ahead with one, how do you determine which category serves him better?
Like I said, it's just based upon the strength of your evidence. Does your evidence promote, or is it more stronger to promote the national interest? Or can we really use your evidence to show that you reach the top of your field? That's going to depend on which application would be stronger. So that's based upon our review of the evidence.
고용주가 없이 진행할 수 있는 NIW와 EB1A 모두 다른 취업 이민 카테고리보다 빠른 수속 기간이 있다는 장점이 있는데요. 하지만 나에게 적합한 비자를 잘 가이드해 줄 수 있는 카운슬이 필요할 것 같습니다. 오늘 LA지사의 김성은 변호사님께서 좋은 말씀 많이 나눠주셨는데요. 저뿐만 아니라 김성은 변호사님께서도 같이 상담을 진행해 주시기 때문에 많은 관심 부탁드리겠습니다. 감사합니다.
감사합니다.